Good morning, thank you, and thank you for those of you who have heard earlier versions of this and have commented on it. What I'm going to do today is tell a story in my limited time, and I'd like to tell you about the background of my current research, what the research questions are, why I think they're interesting research questions, how I've addressed them, and they're not preliminary, but my findings, and then some implications, I think, from the actual findings themselves. And I'm embarrassed to do this once again. The title is Examples from the UK and Australia. The new title is Today It's Just the UK. Okay, and I'll explain why that is. I apologize for that. One of the things I'm really interested in a series of research projects, including this one, is understanding the intellectual property disputing process in the shadow of the formal legal system. And it's a hard space to study and to understand, but it's where most intellectual property disputes are actually asserted, resisted, and resolved. And in a series of articles, I've attempted to look at what it looks like in the patent space, in the trademark space, in the copyright space. And I'm looking at this from drawing on the literature, the Law and Society literature on the disputing process, which has had a lot of studies of the disputing processes outside of the formal legal system in the shadow of it, in the 80s and 90s in particular. And I'm also interested in especially understanding lawyers' roles in these disputing proceedings, drawing on the sociology of legal professions literature as well. And one of the things that I have done in a U.S. example on the trademark side is looking at enforcement of potential trademark disputes. And most trademark disputes are, as I said, asserted and enforced outside of the formal legal system. Things like cease and desist letters, and what trademark lawyers do is they pick up the phone, they send letters, and they negotiate private settlements with lawyers and with targets all of the time. And one of the findings, a subset of findings in my U.S. study, was looking at how and why and with what results that sometimes trademark lawyers and the trademark owner clients are able to over-enforce trademark rights outside of the formal legal system because it's effective under certain conditions and certain circumstances. And there's, by now, if you go to Tom McCarthy, there's a trademark bully section, so we have a subset of trademark bullying literature now that is going on. And I'm interested in that space. And one of the things, 4 years ago, I think today, at IP Scholars Conference, was it 4 years ago we were in DePaul? Mm-hmm. It would have to be, right? I gave a talk on my U.S. example, and Lisa Ramsey said, well, you should look at the enforcement of trademark rights in Australia and the UK because they police, by statute, they police pre-litigation enforcement. And it would be a nice example, and it took me a long time, and it's still not done, but the UK part is close to being done. And so thank you, you get an asterisk, some cosmic credit for that, to push me in that direction. And so what I'm doing in this project, and I'll look at just the UK section, is looking at, in 1994, the Trademark Act in the UK was amended to emulate what had previously been in the patent statute from the 19th century. There's a statute that enforces so-called unjustified threats of bringing legal actions in the trademark space. And so I'm looking at, one of the things I'm interested in is understanding what the disputing process, mapping and understanding the trademark disputing process in this different jurisdiction, but also understanding what, if any, is the effect of the statutory provision on the actual behavior and advice that lawyers give when they're policing trademarks in a regime. So that's, and I'm looking at the UK. I say the UK, half of it was London, because it was easier, okay, and the other half was the outside of London. So I'm looking at the unjustified threats statute in enforcing and trying to test, again, both mapping and then trying to test what is the effect of the statute on lawyers' actions and their advice to clients. And the way that I chose to do this was it's a qualitative empirical study based on data from face-to-face, primarily face-to-face, some telephonic, semi-structured interviews that are tape recorded and analyzed, and asking lawyers about what it is they do in their everyday practices and explaining why they do it and how they give advice to their clients in the disputing project. So that's the methodology, and let me talk a little bit about the statute I didn't jump to the statute because it's actually currently controversial in the UK, and there's discussions as to how it needs to be modified, et cetera. So I was studying this in a period in which the lawyers and the local bars are self-reflective about, is the statute working the way that it should work. But the broad contours of the statute, the unjustified threat statute, it provides for sanctions for any person who's aggrieved where there's been a threat of bringing trademark proceedings for registered trademarks. You have a remedy if the threat is in fact an unjustified threat and you actually can establish that there's a resultant injury or harm. Okay, broad exceptions to the statute, and I'll talk about that. The statute is interesting as to why they thought there was a problem in 1994. Is it the same or different problem that they thought they were addressing with the original unjustified threat statute in the patent history? It was a 19th century patent problem. Why they think there was something relatedly problematic in the trademark sphere is an interesting assessment in and of itself. The statute has broad exceptions. So when I assess how effective is it, well, it's as effective as it's drafted in some respects as broad exceptions. It's somewhat unremarkable. So one thing I'm interested in figuring out, it doesn't apply, for instance, to passing off as opposed to registered trademark infringement. It applies to meritless filing of trademark actions. As we'll see later, the attorney said, mine isn't meritless. We're doing God's work and we're enforcing my trademarks. You know, the other guy's stuff is always meritless, but mine has some merit, okay? It doesn't apply to passing off, and there's some other significant exceptions. It interestingly provides relief, monetary relief, injunctive relief. Relief, including monetary sanctions, are not just against the client potentially, but against the lawyers themselves, which is an odd feature in the UK statute. The lawyers themselves have some personal risk if they're sanctioned under the statutes. And when I say lawyers, as a quick aside, since the legal profession is different in the UK, I actually looked at trademark lawyers who are a different profession in the UK. I mostly talked to trademark lawyers, trademark solicitors, and the very occasional trademark barrister. So I looked at the different segments of the legal profession. There are only several barristers that I spoke about, with mostly as trademark lawyers and trademark solicitors. So the preliminary findings, I'm going to jump to the preliminary findings, including when I asked the question, and I never raised it at the very beginning, how many times have you been the target in negotiations of a trademark unjustified threats cause of action? I've interviewed over 60 lawyers. How many times do you think they've ever been the target of a threat? And it was funny to ask that face to face, by the way. How many times? 0 to 1. Okay, 0 to 1. 0 to 1. There's very few published cases under the statute. The lawyers are all very aware of the statute. They're smart lawyers. They're aware of the potential sanctions for making threats. And yet they do make threats nonetheless. And they have a variety of arguments and tactics for why they think the threats actually get them outside of the risk of the statute. So one of the things I'm interested in, actually my most definite finding, by the way, is, especially based on the face-to-face London lawyer interviews, and this is a pretty good-looking crowd too, by the way, but they are dressed better than all of us put together. And I felt very frumpy in my very sensible travel blazer to be interviewed, and the London lawyers are doing very well in London right now. But they did spend time speaking to me. If I don't see another cufflink, I can, that's fine with me. They're beautifully dressed. Okay. Preliminary finding: great dressers. They are aware of the statute because they face risk. They have to advise clients about the potential risk. Their own understanding as to how much does the statute affect their everyday behavior is, quote, not at all. Quote, it's ideational or theoretical risk. I know that there's a risk, but it's not a real risk. It makes our letters more challenging to some extent, but it isn't that challenging to get around how you draft letters. One tactic: sue them for passing off, or make a threat for passing off. Don't call it a registered trademark. I mean, that's not a huge barrier, okay? It's mostly ammunition, according to some of the interview data. It's mostly ammunition. You can make those threats, but nobody really believes that they're legitimate threats under the statute for the reasons I'll elaborate in just a second. They aren't that significant. It's a minimal actual risk. You do have to, if you're the target of somebody making a threat against you, saying, look, this is an unjustified threat that's taught, you do have to tell your client there's a potential risk under the statute, and it's also maybe your malpractice carrier. So it's not as if they don't think that they actually have to do something in their everyday practice, but it's minimal. It doesn't really affect a lot of what they're doing. It doesn't change when the client wants it, according to the interviews. It doesn't change those circumstances in which the clients really think it makes sense. It makes business sense to be a very aggressive trademark enforcer. The statute itself doesn't seem to have much effect. The lawyers are smart lawyers. They have tactics and abilities and rationales for being as aggressive as they need to be, depending upon what the client needs are. Okay. Some clients, I had one series of interviews with people in the fashion industry who have a reputation for being very aggressive trademark and copyright enforcers. And this person says, yes, when my client thinks it makes sense to go after the very marginal cases in trademark law, the statute, they explain why the statute really isn't that much of a barrier to that tactic. Okay, we ignore it, it's irrelevant, little fear. So one finding is there's perceived risk, very little risk of sanction in the everyday practice. Okay. Second, the lawyers bundle up in that. The second major finding, I think, is that the lawyers see the unjustified threat statute just as a tactical and rhetorical device. Both of them are on the receiving end. Are they afraid when the other side says, you've just made an unjustified threat? No, they get that that's part of the dance and part of the negotiation, but it isn't something that's fully driving at a deep level a lot of their behavior. They see it as a negotiating tactic. It's not something that, as I said, that they've ever actually experienced. It was always, it was triple hearsay as to who they'd actually known had ever had an action brought under the justified threat statute. I think a former colleague at a different firm 5 years ago told me about his colleague who had and I think that case went to trial. Most of the lawyers thought that bringing an unjustified threat to avail themselves under the statute was itself risky, for obvious reasons. The statute is policing informal behavior in the private negotiations. And what is your legal remedy? To bring a lawsuit. Are there barriers to bringing a lawsuit? Yes, 100% of the time, you'll be countersued. Okay, suddenly it's no longer a negotiation, it's called a lawsuit. Now, are there any other barriers? It's expensive to bring a lawsuit, the lawyers say. That sounds familiar. There's lots of uncertainty. The judges themselves, there's a lot of subjectivity. Reasonable people can agree or disagree as to whether a threat itself is unjustified. One way to make it not unjustified is to file a lawsuit. There, it's 100% justified. This is policing pre-lawsuit experiences. Okay. Another finding, so it's risky itself. There's significant barriers, and even when I was there the last set of interviews, the civil procedure rules had just been amended to raise the cost for filing lawsuits, most lawsuits, and so the actual economic costs of availing yourself under the statute changed as well. And then one last thing that I did find is that the local legal culture and local understandings and consciousness of law, a lot of the lawyers saw the unjustified threat statute as being somehow incongruous with more recent amendments to the civil procedure rules, which seemed to advocate for robust negotiation, and there's rules pertaining to cease and desist letters or letters before action, and the lawyers themselves, many of the lawyers themselves talked about, I think those kind of pragmatic rules trump this more theoretical set of rules with regard to the formal legal sanction that can be brought for filing, for making an unjustified threat. And so I got a sense of what their understanding was and how they advised clients as to why we should be doing this, because of civil procedure rules, and the judges like the civil procedure rules. They're not going to want us to not have taken these steps before filing a cause of action. Okay. And one last finding that actually struck me because it was different. It was when I did the U.S. version of this a number of years ago. I heard this, but it was a much fainter and fewer patterns showed up in the U.S. interviews. But it struck my ear that of the 60-some lawyers that I spoke with, virtually all of them spoke about how they gave advice to their clients and how they themselves processed the PR hit that an overly aggressive trademark enforcement can bring on for their clients, and how they advise. Some of their clients don't care. They like having a reputation as being aggressive trademark enforcers. There's some prophylactic effect, according to them. But most of the lawyers were pretty articulate as to what the potential public relations costs were. In fact, I like the phrase "trial by Twitter." And I wonder if something's changed if in the years between it's only been 6 years, but when I did the different U.S. data and the current data, is there a change in terms of social media? The social media is so much more readily available, and is there a set of practices that people are actually thinking about doing this more and resisting unjustified threats? But the lawyers there, again, their perception was that there is a change, that there can be a PR hit. And whether it's empirically true that it's more or less or greater, that's how they're reacting to it, and that's how they're giving advice to their clients, the trial by Twitter. Okay? So my ultimately unremarkable set of findings is the statute fully effective? Well, no, but that's unremarkable. Statutes, do they always have, exactly the intended effects? Depends on the statute, depends on what the statute says, what limitations it has, what gaps there are. Lawyers know how to work around statutes. So is the statute fully effective? No, but again, it's not surprising that lawyers know how to work around statutes and avoid risk or minimize risk, okay? But I'm interested in figuring out what exactly the lawyer's role is in this process. It's unremarkable that they do have a role. How do they do it? Understanding the logic and how they mediate between potential sanctions and how they give advice to clients and how they enforce trademarks. I think it's pretty clear from this that trying to, and I think this is where I want to push in terms of understanding the broader implications of this trademark study in the UK and in Australia as to what implications does it have in policing this free litigation behavior in the US in a variety of contexts, including there's a lot of activity to regulate trademark bullies. Leah's done a lot of work on that and has had good suggestions for the study. But trademark bullies, copyright bullies, patent trolls, whatever the term of the day is, there's real problems with using the form of legal sanctions and changing the law to police those behaviors. And I think these studies do give some clues. I'm trying to flesh out what that means, including look at the limitations of all sorts of regulations. I was thinking from a lot of the data, very similar when I looked at patent litigators in discovery disputes and their dismissiveness about Rule 11. Do you think that in the midst of aggressive litigation, the threat of a Rule 11 sanction for being fast and loose in patent discovery really affects many lawyers' behavior? And in the previous study, the answer is largely no, and there's lots of reasons, including we have more pressing concerns in the midst of litigation. Our clients want us to do it, and that's the answer, right? Whether or not there's sanctions are theoretical. Judges never issue sanctions, their own understanding, things of that nature. So I think there are implications that I haven't fully spelled out in terms of understanding, again, lawyers' roles and understanding the limits of trying to police this type of behavior. And I'll stop there and see if there's any comments or questions.
I have one comment and a question. I think you may be underselling your findings in that a lot of the policy debate in the UK is about curtailing it and the proposal of the Commission. So there's a public perception that it's actually too strong and is actually undermining IP. And so, even though we as academics all know that law and things are in the shadow of the law and there's a difference there, and I think it's probably the findings are correct. They're very relevant and counteract some of the directions the law is going, especially with what we see with controlling behavior and so forth in all areas of the law. But then my question is, how do you select your sample for lawyers for interviews? Because did you have an accurate representation of plaintiff defendants? Because since the interviews of this kind, and I've done some myself, you always have to be careful for demand effect. And so, for instance, if you talk to plaintiff lawyers, they will say, "Oh, I'm not worried. I know I can work around this." So it's important also to talk with defendants who have the reverse demand effect to say, "Well, I can really make this work. These groundless threats." So
really good points. The sampling was a non-random sample. It was an opportunity sample technique, which I especially needed with UK. using a snowball sampling technique, identifying some people and having them identify fewer people. And the characteristics of, I don't know the exact numbers, but I got primarily plaintiffs' lawyers, although they were also on both sides. So I got some of their defense sides, even though they were nominally trademark lawyers for the plaintiff. And I did get a substantial number of both in-house and private lawyers who worked on the defense side, but it was weighted in terms. It's clearly something to think about. I agree with them.
So I think, as you know, again, here's a great project. What I like is kind of seeing how Rule 11 in the U.S. and maybe anti-SLAPP and other statutes we have to be distinguished. You know, maybe people care about it, maybe they don't. Groundless, that's here too. But I agree with Ben that I think it's, you know, there's some benefits to having them on the books, even if people don't worry about them so much, because that's all part of the negotiation. So I think one thing to think about is, so as a result of what you found, you know, would groundless threats, action, or something similar add to what we already have in the U.S., or is Rule 11 anti-SLAPP enough? I mean, that's, I guess, one thing to think about, because some people, when I have a student who's proposing we need something similar. Or perhaps does it mean that we need to do other things? For example, maybe increase certainty in the law, come up with more rules and standards, so that because of the fact that these kinds of rules, I mean, the problem is that this just increases litigation, right? And so the people that can't afford to litigate, individual small businesses, regardless of you know, how right they are or whether they win, are probably not going to be able to even file a groundless type suit, or spend the cost to argue a Rule 11 violation. And so that's why I think the brilliance of Leah's work of shaming trademark bullies, and you know, the trial by Twitter and others who've suggested we do this on the internet, other areas, social media, is just wonderful, because it's very cheap to do that. And I mean, there's a downside for brands because sometimes they're unfairly targeted, but perhaps that, you know, I think that would maybe be one of these takeaways, is that we have, like you said, all these new technologies that are making it easier to expose what's going on. And I think that's what's so important is the more information we have about transparency about what's going on, I think can help us make decisions on you know, what to do.
Yeah, really good points, and that's why I do like your more recent proposal where it's multi-pronged, even though I think each prong separately has its own limitations, right, for a lot of the reasons, but it's multi-pronged, and that's what we probably what we do need. So thank you for those comments and insights.